Hi, my name is David Zimmerman. I'm Assistant Director of Human Resources with the Allegheny Intermediate Unit. I'll be reviewing the module today on student abuse. The goals of this module will be to define student abuse and understand the reporting process for student abuse. Let's begin by looking at the history of student abuse. Act 151 of 1994, signed into law on December 16, 1994, amended the Department of Public Welfare's Child Protective Services Law, or CPSL. The purpose of this notice to the schools is to outline those changes which affect the school's policies and procedures regarding the reporting of suspected abuse of students by school employees and background checks for employment. It is important for school administrators to be aware of the following summary points regarding Act 151's amendments of the Child Protective Services Law. The amendments establish a separate category of abuse called abuse of a student by a school employee, which involves either serious bodily injury, sexual abuse, or sexual exploitation. Effective July 1, 1995, school administrators must report suspected abuse of students by school employees to the district attorney and the local police. We will review this further in the student abuse reporting process. We will review the three components of student abuse. A student must be under the age of 18 and be enrolled in a public or private school, intermediate unit, or VOTEC school. A school employee is any person employed by a public or private school, intermediate unit, or VOTEC school that has the possibility of coming into contact with children. School employee includes subcontractors, for example, non-instructional staff, bus drivers, custodians, cafeteria workers, after-school and extracurricular activities being provided by a paid or contracted person, and so on. It only excludes individuals who have no possibility of having contact with children. This also excludes volunteers, as they are not being paid or contracted by the district. Anyone the school district pays is considered a school employee by definition of the CPSL. For example, a teacher that is providing instruction to a child outside of school, perhaps in the child's home, and is being paid by the school is a school employee, and if they were accused of abusing the child, they would fall into the student abuse section. However, if the parent hires a teacher to privately tutor their child and the parents pay for it, the parent then is placing the teacher as a person responsible for the child's welfare under the perpetrator category, which if they were accused of abusing the child, it would fall into the category of child abuse. To make it easier to remember, follow the money. Whoever pays in this example will determine the category of child abuse as a perpetrator or student abuse as a school employee responsible for abusing a child. The third component is abuse of a student by a school employee that causes either serious bodily injury or sexual abuse or sexual exploitation of a child. As a reminder, sexual abuse or exploitation involves the employment, use, persuasion, inducement, enticement, or coercion of any child to engage or assist any other person to engage in any sexually explicit conduct or any simulation of any sexually explicit conduct for the purposes of producing any visual depiction of any sexually explicit conduct, or the rape, molestation, incest, prostitution, statutory sexual assault, or other form of sexual exploitation of children. Now let's look at some additional definitions found in the Child Protective Services Law. An administrator is the person responsible for the administration of a public or private school, intermediate unit, or area vocational technical school. The term includes an independent contractor. County agency is the County Children and Youth Social Service Agency. A public or private school refers to all schools in the Commonwealth, including public and non-public schools, as defined in the school code, and private academic schools as defined in the regulations of the State Board of Private Academic Schools. Private rehabilitative residential institutions and other day treatment programs, which may not fall within the definition of the term school, are still subject to the child abuse provisions of the Child Protective Services law. A subject of a report is the child, parent, guardian, or other person responsible for the welfare of the child or the school employee named in the report of suspected abuse of a student made to the Department of Public Welfare or a county agency under the Child Protective Services law. An unfounded report for school employees is any report of student abuse unless the report is a founded report for a school employee or an indicated report for a school employee. An indicated report for a school employee is a report where an investigation by the county agency determines that substantial evidence of serious bodily injury or sexual abuse or exploitation exists based on any of the following: the available medical evidence, the county agency's investigation, and an admission of the acts of abuse or injury by the school employee. A founded report for a school employee is a report where there has been any adjudication based on a finding that the victim has suffered serious bodily injury or sexual abuse or exploitation, including entry of a plea of guilty or no contest or a finding of guilt to a criminal charge involving the same factual circumstance involved in the allegations of the report. A school employee who has a reasonable cause to suspect that a student coming before him or her in the employee's professional or official capacity is a victim of serious bodily injury or sexual abuse or sexual exploitation by another school employee shall immediately notify the administrator. This reporting requirement applies whenever a school employee is suspected of abusing a student and is functioning in his or her role as a school employee regardless of when or where the abuse or injury occurred. Please note, if the accused abuser of a student is the administrator, the reporting school employee shall immediately report to law enforcement officials and the district attorney. The student must be physically seen by the employee before the school employee is mandated to report the suspected abuse or injury. When a school employee learns of suspected student abuse from another person, the school employee shall see the student and make a report of suspected student abuse if the reporting school employee has reasonable cause to suspect that the student was a victim of serious bodily injury or sexual abuse or exploitation by a school employee. The reporting school employee may not reveal the existence or content of the report to another person. A school employee who makes a report in good faith of suspected abuse of a student by another school employee or of child abuse is immune from civil and criminal liability arising out of the report. Any school employee who willfully violates a reporting requirement commits a summary offense for the first violation. Any employee who commits a subsequent violation is guilty of a misdemeanor of the third degree. An administrator, upon being notified of suspected abuse, shall report immediately to law enforcement officials and the appropriate district attorney the suspected abuse or injury alleged to have been committed by a school employee against a student. The same reporting is required if the administrator suspects the injury or abuse. When a school employee notifies an administrator that he or she suspects that a student is the victim of serious bodily injury, sexual abuse, or sexual exploitation, the administrator may not make an independent evaluation or investigation to decide whether or not to make a report to law enforcement officials and the appropriate district attorney. The Department of Public Welfare's Report of Suspected Student Abuse CY 47-D form is completed by the administrator. The report is different from the Report of Suspected Child Abuse CY 47 form. The CY 47-D form for student abuse includes the student's name, age, address, and school, and the name and address of the student's parent or guardian, the school administrator, and the school employee suspected of the abuse. The nature of the offense and any comments or observations relevant to the incident must also be included. Law enforcement and the district attorney will coordinate an investigation of the report and determine what, if any, criminal charges will be filed against the school employee. When they have reasonable cause to suspect abuse of a child by a school employee, they immediately contact the County Children and Youth Agency. The County Children and Youth Agency immediately notifies Childline and begins an investigation. Prior to the initial interview with an employee suspected of abusing a student, the county agency must orally notify the subject of the report about the existence of the report, the allegations of the abuse, and his or her rights regarding amendment or expunction. Written notice shall be provided to the subject of the report within 72 hours of the oral notification. Notice may be reasonably delayed if notification is likely to threaten the safety of the student or the county agency worker, to cause the school employee to abscond, or to significantly interfere with the conduct of a criminal investigation. The county agency shall notify, in writing, the school administrator or employee who made the report to the district attorney and law enforcement officials of the status of the report that is founded, indicated, or unfounded when the investigation is complete. Willful failure to report and cooperate. For school employees, a school district, facility, or any person acting on behalf of a school district or facility that willfully fails to cooperate with the Department of Public Welfare or county agency when investigating a report of child abuse or suspected abuse of a student by a school employee, or when assessing risk to the child, commits a summary offense for a first violation and a misdemeanor of the third degree for subsequent violations. An administrator who reports suspected abuse is immune from civil or criminal liability arising out of the report. In cases where the administrator is the employee suspected of abusing the student, the school employee who suspects the abuse shall immediately report that information to law enforcement officials and the appropriate district attorney. The law requires the administrator to report suspected abuse immediately. An administrator who willfully violates a reporting requirement commits a misdemeanor of the third degree. Nothing prevents the school from conducting its own investigation after making the report to law enforcement and the district attorney. However, the school district is urged to coordinate its investigation with its local law enforcement and child protective services so as not to jeopardize any criminal investigation or prosecution. School may take any action that the school district deems appropriate in accordance with provisions of the school code and district policies and procedures. The school code requires school officials to report to the Department of Education when an employee is dismissed for cause. Therefore, if an employee is dismissed because of abuse of students, the school officials must report the dismissal to PDE. School officials must also report when an employee is formally charged with or convicted of a crime of moral turpitude. Because child abuse and abuse of students are crimes that involve moral turpitude, school officials must report to PDE if an employee is charged with or convicted of one of these crimes. The school's mandatory report form is located on the PDE website, and procedures are in the Basic Education Circular section. Now that we've reviewed the module for student abuse, let's check for understanding. All schools are included in student abuse, including public and private schools defined by the Public School Code and private academic schools. True or false? The answer is true. Student abuse is comprised of three components: a student, a school employee, and a type of abuse. True or false? The answer is true. An administrator shall report immediately to law enforcement officials and the district attorney any report of serious bodily injury, sexual abuse, or sexual exploitation alleged to have been committed by a school employee against a student. True or false? The answer is true. What is the correct sequence of the student abuse reporting process? Is it A, school employee to Childline, to administrator, to law enforcement and district attorney, to children and youth agency? Or B, school employee to administrator, to law enforcement and district attorney, to children and youth service agency, to Childline? The answer is B. An administrator who willfully violates the law regarding the reporting of student abuse commits a misdemeanor of the third degree. True or false? The answer is true. School districts are encouraged to take prompt action adopting policies and procedures which will meet their new obligations under the amended Act 126 Child Protective Services Law. At a minimum, schools should inform employees and contractors who provide services to the school of the major provisions of the law and their responsibilities for reporting suspected abuse. Establish reporting procedures with local police and the district attorney. Inform parents and students of the law and of the appropriate procedures for informing school staff of situations which fall under the scope of the law, and contact the local county children and youth social service agency regarding its procedures relative to the amended Child Protective Services Law. Issues related to abuse of students, as well as child abuse, should be part of the school district's comprehensive violence prevention program. Planned training programs should be used to inform school employees of their responsibilities under the law and the steps to take to prevent the occurrence of abuse of students. A comprehensive violence prevention program is the primary starting point for dealing with any form of abuse. Any organization that works with children is required by law to obtain for their prospective employees both a criminal background check and child abuse clearances, which are obtained from Childline's Child Abuse Registry. Child Protective Services will respond to student abuse complaints. Childline is available 24 hours a day, 7 days a week to receive reports. An investigation begins and includes risk and safety assessments. There are interviews of the child, the perpetrator, and others involved, and a visit to the child's home may be necessary. Emergency protective custody is only permitted by a physician, a medical director, or law enforcement, and children and youth must obtain a court order. Child Protective Services also collects evidence. After the investigation is complete, mandated reporters are entitled to limited information. Children and youth agencies are required to automatically refer a case to law enforcement for criminal investigation in these circumstances: homicide, sexual abuse and exploitation, serious physical injury, serious bodily injury, and abuse perpetrated by a non-family member. Be proactive and understand that as a mandated reporter, when you have reasonable cause to suspect child abuse, it is your legal obligation to report it. Cooperate with investigations and focus on building positive relationships with colleagues, administrators, local law enforcement, county children and youth agencies, and the appropriate district attorney. Thank you for your attention. Please proceed to the next module.